Lawyers, what's the most obscure law that you've actually used in a case? A law professor of mine was representing someone who owned a goose and was being sued by a neighbor because the deed said no geese. When the deed was written, the singular and plural weren't interchangeable. Professor said deed only said no multiple geese and one goose was okay. Judge agreed. My brother and his roommate got away with something similar in college. They threw a major Wega party for their birthdays, both on the same day. Awesome townhouse party. RM. One I heard from a criminal defense attorney in law school. His client is driving down a country road at night without any lights on. A police officer is parked off the side of the road and, seeing the man drive by, pulls out behind him to follow him but also doesn't turn on their headlights. Eventually they pull the man over and find that he has a lot of cocaine in the cab of his trunk. Charges are brought for possession with intent to distribute. They get to court, and the attorney cites the fact that, under the relevant state law, it is not legally required to have your headlights on at night unless there is another vehicle visible within 500 feet of your vehicle. Because the police officer was also driving without headlights, the man had no reason to see them, and therefore he was legally allowed to drive without his headlights on. Because of this, there was no reason to have pulled the man over. Thus, the discovery of the cocaine was fruit of the poisonous tree. i.e., any evidence that is discovered improperly must also be excluded. Case dismissed. Canada has an Apology Act stating saying sorry does not show responsibility or take blame for the situation you may or may not be at fault in. I can see how that could be a need in Canada. Legitimately, we are an extremely apologetic people. Any mildly inconvenient social interaction, like gently bumping into someone behind you, is followed by at least 3 sorries from each party. Englund v. Carey. We read a contracts case back in school that ultimately came down to the issue of whether a hot dog was a sandwich. There's a Supreme Court case about whether a tomato is a fruit or veg. How? One is a culinary term and one is a botanical term. They aren't mutually exclusive in any way. Tomatoes are a veg. I haven't used it yet, but the other day while researching a related issue I stumbled across a 100-year-old case that says summons served on Sundays were no ab initio. Hasn't been overruled, although it's probably dead letter. If I ever have to dispute a summons that was served on a Sunday, I might pull it out and see how it goes. Not a lawyer, but one time I had to sue a landlord who made up some pretend reasons to keep my security deposit. I spent a Saturday in the law library at the local university and found a law that would let me win my lawsuit and claim triple damages. The landlord read my lawsuit and offered to give me my deposit back plus $500. Sweet. What was the law? This was nearly 30 years ago, so I'm not going to get it exactly. But something to do with what pretext a landlord may use for holding onto a security deposit in New Jersey. As I recollect, he claimed that we had an extra tenant not named on the lease. However, he had approved the tenant and only complained at the end of the lease. I believe the law specifically prevented withholding a security deposit in that situation. Wish I could remember better, but it just goes to show that a Saturday afternoon and the law library can pay for itself. I routinely cite a 1921 case regarding a forged railroad ticket when I'm trying to argue the best evidence rule of an original that's later been marked up with pen or has some notes on it. The case says that if something is printed out containing all the elements of what it's trying to do, then any handwriting on it is evidence that it's been altered, and the alterations must be shown to be lawful by whomever seeks to enter the item into evidence. Very good to use to keep things out of evidence. I didn't, but worked in an insurance litigation firm where a guy used an 1800s maritime law to defend a case that occurred on a boat on Lake Michigan. He wanted to get it out of state court and into federal court where civil verdicts usually have less value in our area. That was neat. My maritime law professor was a glorious arsehole, and I'll never forget the story he told. For this, you need to know that below the mean high tide line on a beach is public access. My professor, in his younger days. Had just finished the bar exam. He went to the beach. The beach was super overcrowded. Just a short walk down the shoreline was a private beach club. This beach and beach club were right near my college, so I've been there and seen both. The beach at the private beach club was wide open and much less crowded. So he walked down the shoreline and parked his chair somewhere below the mean high tide line. A few people from the beach club tried to get him to leave since he wasn't a member. But because he was in the public access section of the beach, legally they couldn't do anything. In the US, cats have the right to roam, meaning cats are free to trespass on other people's property and essentially they're creatures of the world. Having a cat in your home that you care for does not necessarily mean you're the master of the cat or liable for its actions in the way you'd be liable for a dog's actions. Of course, there are exceptions where a cat's bad behavior is within your reasonable control and you did nothing to prevent it. Cat law. YOL. http. Cats away. Org cat law. Are you sure that link is applicable to the US? It has quite a few references to the UK. Magistrates Court and Crown Court. Even right to roam is a UK concept, in humans. It governs the rights of members of the public to cross private land freely, as long as they're behaving themselves, e.g. hikers. A client of mine was writing a scathing review of the Australian court system which he intended to publish in a book. When advising him regarding defamation etc., I ended up dredging up an old Australian law scandalizing the courts whereby a person commits an offense if they incite disenchantment or distrust to the extent that it undermines public confidence in the judicial system. Sort of publicized contempt of court. That's Thai. How else can we change systems, or correct them, if we are not allowed to criticize them? I don't know if this would be interesting to anyone else, but I drafted an MSJ last year where an insured inland marine trucking company had mistakenly delivered a filled cargo container back to port instead of the client, and it was shipped back to China where it was held by customs and the cargo was eventually destroyed. The insured's policy did not cover mishandling, misdelivery or misplaced cargo but provided coverage for all non-excluded losses. They tried to argue that, in misdelivering the cargo, they had lost it and, thus, it fell under the policy as a non-excluded loss. It only took them a week or so to locate the cargo on its way back to China, so it was never lost, but they still tried to claim that a loss in an insurance contract included anything lost. Double quote. Dumbass argument, but the partner took out my entire section addressing the definition of loss, as in to lose, and loss in an insurance context, as in the mon. I had to give advice to a public entity about the US flag code. An employee had raised a grievance that the way the flag was hung in a particular room violated the code. Technically, the employee was right. The question was what kind of remedy was enforceable under the flag code for a violation. The answer: none. Petty. Upset employee got no satisfaction. Isn't the obvious remedy to hang the flag correctly? Not if the flag code doesn't include provisions to force people to hang it properly. A list of this is what you should do without any corresponding list of "and here's what happens if you don't" is just about as good as a suggestion pamphlet. Work for a debt collection law firm and we also do some subrogation work. State of Michigan has a law on the books from back in the day whereby cattle are exempt from liability in automobile accidents. Case involved an accident due to the cattle going across the road pretty suddenly and there was a car on cattle collision. Guess who got blindsided in court by this law from the 1800s? The judge? Not yet applicable. But in case a no-deal Brexit goes trough, 50 Bruges fishermen can continue fishing in British waters because of charter from 1666. One fisherman already tried his luck, and the British were advised to not pursue the case because most likely the charter is still in effect. A full article on this. Left square bracket. This reminded me of a story heard from a buddy working at one of the big four auditors. When asked a similar question, they had a client that was from a EU country, reside in UK, starting a business, and somehow start the process to move to Canada. but not finish it. In the meantime, the business started in the UK, hit it big, and he got to sell it for 50+ mil USD. Now the question of taxes arises, as he's not British, but earned the money there, but was in the process of moving to Canada, and so on. It was a hard problem, until my buddy found an obscure colonial era treaty between UK and Canada. Said treaty stated something along the lines of a person's wealth can change residency virtually, if the owner wishes to lay his soul on the territories of Canada. So the income in UK would be taxed by Canada, but only upon completion of such a transfer, meaning that it would only be taxed when it actually reached Canada. So said client had to pay no taxes in the UK, and would eventually pay some lower taxes in Canada after he finishes the process of changing residence there. Client was happy, and suddenly not in a rush to move to Canada. As you can imagine, I might mix up some of the terms because I'm citing from memory, but the gist should be the same. Obligatory now. But I work at a lawyer's office in Germany. One of our lawyers managed to get our client off a speeding ticket by finding out whether or not you needed some sort of specific certificate to be allowed to operate the radar speeding gun. He found out there indeed was some obscure certification, of many, that is needed and is supposed to be renewed every 2 years or so. The officers who wrote the speeding ticket hadn't renewed theirs in a while. Apparently nobody did, though nobody even really knew about that specific certificate. He won the case. The judge agreed they shouldn't have been operating the radar gun without the certification, even though the dude really was speeding. Allegedly speeding. We will never know since the officer with the radar gun didn't have the proper certificate. He might have mishandled the radar gun or used it on another car. Typical mistakes for those who aren't certified. I cited a 1500s case from the UK on gravarobbing that stated that property can never be ownerless in a dispute over the ownership of a pile of dirt. I also cited a 1700s case on interpreting the rule against perpetuities. As a lawyer, I just had war flashbacks when I read rule against perpetuities. Car sales tax case. Client has to post amount of disputed tax and then ask for the money back before getting an opportunity to sue to get money. There are also interest and penalties if you do not send a letter asking for the state to not pursue. State can still go after client even though case is pending. On the letter to request the state not pursue, at the top must be written in red ink specific words, or the state can ignore the letter per the regulation. This case has been going on since 2006 and haven't been able to file a case yet in court. Also, state never actually has to respond to the request for refund. Where I went to school, the conservation law students had to do a paper on if hunting on horseback is considered hunting with the aid of a motor vehicle here in NY. The answer isn't what you think. The Police and Criminal Evidence Act, 1984. Permits the police to take a sample of semen from a suspect in custody. Good luck with that. You can have it, but you have to get it. I do remember hearing a story where this guy in Michigan was arrested for underage drinking, but was only a couple of months away from turning 21. He went to court and pulled out an abortion law for Michigan stating that life begins at conception. So when he asked the judge if this law was still valid, which it was, he then stated that since that was the case, he was technically over 21 years of age and legal to drink. The case was dismissed. And when the prosecutor made a stink about it, the guy said, "Hey, it's your rules." When I was in college, a girl who worked at an expensive law firm told me this, and I always wondered if it was true. She said that when Oklahoma passed a new drunk driving law, that they specifically mentioned the breathalyzer machine that the cops had to use, and since it was a new one, most places didn't have it. So if you got a DUI and they didn't use that machine, or even owned old ones, you could get it dismissed by saying they weren't compliant with the law and used or could have used the old ones. She said they had gotten cases dismissed using that argument. The legal definition of massage is so ridiculously overbroad in my state that it literally covers getting water pumped up your colon to clean out all the poop. We have a statute that prohibits certain kinds of car insurance from reimbursing providers for massage. I was dealing with this shady fly-by-night clinic that offered a bunch of bull services that didn't do anything. They were really just a massage parlor that pretended to do other to get around the billing issue. So I argued that everything they did was technically massage under the statute. Not exactly a law. But if there's a no-deal Brexit, all kind of old treaties between European countries and the UK kick in. I know some countries are already proactively retracting old treaties to prevent weird or unwanted stuff from happening. Can give sources but can't find them in English this fast. To make things more complicated, French, Belgian and Dutch fishermen have a lot of boats under UK flag and using UK fishing quota permits as those were easier to get some time ago. But in practice they sell their fish on the continental market. How will this hold legally after Brexit? Depends on which old treaties are still active. I found one beautiful example already. Belgians can fish in British waters thanks to 1666 Charter. I've cited a 19th century bestiality case from the Indiana Supreme Court as persuasive authority to an Illinois court. The defendant was convicted of having with a chicken. The Indiana statute referred to an unlawful union of man and beast. The defendant appealed, and his defense was that the dictionary definition of beast was a four-footed cloven-hoofed animal. The Indiana Supreme Court affirmed the lower court with some beautiful language about statutory interpre. It's obscure case law, not a statute. A co-worker of mine used a court decision from the 1880s to successfully defend a do, and someone was trying to invalidate over an issue concerning a notary stamp. The stamp was clear enough to read, but had a slight smudge that the other side argued made it invalid. They were able to keep the do and out in an administrative hearing, and won the case on that level based on that. We appealed it to district court. My co-worker found a case from the 1880s where the court described a notary stamp smudged in the same way and ruled it was valid. This was the only case she could find that addressed the issue. Based on that precedent, the district court overruled the administrative court and reversed its decision.